Yeah, a lot of people are upset that Kris never disclosed that it was created by AI, but I mean, like, if never asked, why would you disclose? Hello, my name is Nadia. I'm a lawyer by day and I'm a hobby artist. So I'm here to discuss all things artificial intelligence in Zara of the Dawn comic, which was created using artificial intelligence and that recently received United States Copyright Office protection. This comic situation started quite a while ago. I think I discovered the creator Kris on Facebook group back in the summer of 2022. And in this Facebook group, they were sharing the ways you can create images. They were explaining really step by steps how you can make a comic using Midjourney. I kind of forgot about this comic at some point and moved on to other things in life. And then at some point, the whole hype started after Kris posted on their Instagram that they applied for United States Copyright Office protection. There was a lot of discussion about it on the internet. And in the end of the day, Copyright Office also realized that comic was created using artificial intelligence. And I think at some point they needed to review their decision. Attorneys of Kris responded to the office and office responded back. And nevertheless, in February 2023, we received the final decision from United States Copyright Office, which is never final because I know that you can always respond or even go further in the court and still request your copyright protection. So I think we'll hear more about this case. So let's read this letter line by line. United States Copyright Office said that we once again looked at the work of Kris. The work was created using Midjourney artificial intelligence tool. There are quite many tools you can use. Midjourney is one of them. And the new conclusion is that Kris owns text of the comic. They also own visual elements and the way the images are allocated. At the same time, the images were generated by Midjourney technologies and they're not product of human, therefore the images itself are not granted copyright protection. I also find that was a very interesting footnote on page 1, where when making a decision about the current case, the office only considered correspondence from Ms. Kashtanova and her counsel. We received unsolicited communication from other people, but we did not use it. And I'm curious what type of unsolicited communication the patent office was receiving about their decision. Were there any haters shouting that AI art is not real art? I would love to hear this letter say, office, spill the beans. I'm curious what opinions the public has. I guess I can find these opinions on Twitter as well. In the next pages, office describes why they thought so. So in section 1 of the letter, they just describe how the comic looks like. And here the office insists that on the cover page, it was only written the name of the author and Midjourney, and it actually was not quite clear that artificial intelligence was used in creating the comic. I find it a very strange. Yeah, a lot of people are upset that Kris never disclosed that it was created by AI, but I mean, like, if never asked, why would you disclose it? Like, no one asks if you used Photoshop or if you used some other tool, special Canon camera. In this regard, Midjourney is also just a tool, I guess. There is a section 2 of the office's letter where they once again mention that application never disclosed that they used artificial intelligence to create any part of the comic. Then there is a section 3, which is actually discussion about copyrightability of comic. And that's quite interesting to see what the office thinks. So first, the office talks about what actually is copyrightable under United States law. And they say that a work can be copyrightable if it's original work fixed in a tangible medium of expression. And speaking about originality, they say this, it has to be independent creation of sufficient creativity. Creativity in the United States law defined very low. So courts are not here to judge what's creative or what's not creative, and judges are not here to define what's art and what's not art. That is why if there is a question of what's creative and not creative, courts usually will take the lowest approach, and as long as there was some effort done, it will be creative. Then there is an interesting discussion about human author. They say that works of authorships are always limited to creations of human authors. And there was a discussion that the person who took photo of Oscar Wilde was not really an author because he just merely performed a mechanical process rather than doing something creative. At the same time, in this case, it was ruled that since the photograph of the person who took a photo of Oscar Wilde actually performed some actions, chose correct light, put Oscar Wilde in particular position, this person actually is an author, and there was a creation of human action, and therefore the photographer who took a picture of Oscar Wilde was granted copyright protection. Then there was a different case when some person claimed that they wrote a book which was authored by non-human spiritual beings. These copyright protections say that idea of copyright protection and intent of law is to protect humans and not divine beings. Therefore, if we're thinking about the discussion in AI, once again, there is a big topic that only humans can get copyright, and machine, divine being, or something else cannot be copyright owner. So that was a discussion on the law that office thought about. I don't know, seems pretty straightforward to me. When I read the section, I thought, okay, I think comic created by AI sounds creative enough for me. And then when I read the Oscar Wilde case, I was like, okay, sounds that a bit same situation here. Kris, as an author, arranged the comic in particular order. Yeah, sounds also copyrightable to me. Then we go to the next section of work text. So the office was thinking about text, and basically there is not a lot of discussion. Office finds that the text of the comic is the product of human authorship, therefore it's granted copyright protection. Then there is a next section where the Copyright Office looks at selection and arrangement of images and text. The office basically say copyright protects assembling of pre-existing materials in coordinated, arranged, and sufficiently creative way. Therefore, the office concluded that arrangement of text in certain ways as a comic and arrangement of images in a correct way, it is human authorship, and therefore Kris is an author for arrangement of the comic. And then we go to the section D, which is very interesting, the individual images. And that's where the Copyright Office thinks that images cannot be granted copyright protection. First, the Copyright Office discusses how Midjourney works. I actually made a different video describing how Midjourney works, and I showed a little bit video of how it does, so I will link this video in description so you can have a look. Then there is an interesting point where the office says that it's not possible to predict what Midjourney will create ahead of time, and that's fair enough. When you type a prompt in the picture, in the field, you can't really know what will end up. At the same time, I can also judge that, when I start drawing, I also very often don't know what will happen. I can just make an educated guess. Like if I mix these two colors, I hope it will give a particular result. And when you type a prompt, especially when you're more skilled and you're typing longer prompts, you can try to type a longer prompt, hoping that it will give a particular result. Basically, what the office was saying is that Midjourney created those images, and even though Kris was given some guidance, in the end it was Midjourney that created the final product of art. They're saying that indeed Kris had to type a lot of prompts, and if the result was not nice, Kris again had to type a prompt and tweak a prompt and maybe add extra words to get the result they wanted. To obtain final images, it's a process of trial and error, where you have to provide hundreds or thousands of descriptive prompts to Midjourney until the perfect vision is possible. So therefore, the office thinks that rather than having a guided task from Kris, Midjourney generates images in an unpredictable way. They once again refer to Oscar Wilde case, saying that in the end of the day, photographer was a mastermind behind the picture of Oscar Wilde, because photographer had a creative vision. Photographer could dress up a model in a certain way, could look at the light, and in Midjourney, user lacks sufficient control over the final image to be treated as the mastermind behind them. And then the office brings really interesting point about works for hire. They were saying that you can think that if Kris commissioned an artist to create a work, and you would tell to the artist, please draw me an elderly woman named R, having curly hair and sitting inside of spaceship, and give a direction, and then you would commission an artist to draw this image, actually an artist would want the final product, even though you were the requester of the image. It might be work for hire, so you will own license, but the person who draw the image will be the artist at the end of the day. It really seems like a very interesting point that it sounds like you are commissioning a visual artist to create a work for you. Further, the office looks at the telephone book copyrightability case and refers to the court decision in the Faced case that just making a lot of sweat but not really having creative spark doesn't mean that you are getting copyright protection. In that court case, they were talking about putting a lot of items in alphabetical order in telephone book. So just a mere sweat, it's just work, but it doesn't mean that it immediately becomes copyrightable work. And there the office says that since indeed you had to put a lot of effort into writing a correct prompt, it doesn't mean that you are becoming a copyright author. Later, the Copyright Office talks a little bit about edits, and first they talk about there were some images that Kris amended in Photoshop. For example, lip was a bit not perfectly drawn. I would imagine hands, because AI can't draw hands. So fixed some errors in Photoshop. It doesn't mean that you're creating a creative work now. At the same time, there was a different work. There was a different image where same character was created by Midjourney, and Kris used Photoshop to age the character in Photoshop. And edits could provide human authorships and could be not excluded from the new registration of the certificate. So basically, talking about AI-generated works, I think the office's opinion is works per se that are created by AI are not creative, but if you put enough effort in Photoshop to later update this photo and actually do something creative, you will be owning this particular picture as it is. And that's actually the end of the letter. Then there is a conclusion. I think I've read that lawyers of Kris are already working on the response, so I think I will be hearing about this case more. What I'm thinking about it, I think, oh my god, that's so hard. AI art will get certain level of copyright protection, in my opinion. In which way? It's hard to say. It's actually also an interesting discussion. If you use same prompt, exactly same prompt 3 times, you will be always getting a different result in Midjourney. At the same time, if you use completely exact same settings on your camera and you take same photograph 3 times, you will receive exactly same photo all 3 times. Could that mean that the office is onto something and that it's actually Midjourney is defining the final result and not you? I don't know. I have to think about it. And I'll be thinking about it. Hopefully I'll share with my thoughts later. Thanks for listening to this rant and bye-bye.